Assistant professor here at the law school, and I'm going to speak about the extraterritorial reach of U.S. antitrust law and its relevance for Indian companies. So first off, I think a starting question is, why is the extraterritorial reach of U.S. law relevant to a conference on law and liberty in India? My main answer to that question is because nowadays just about every major company operates in more than one jurisdiction. What does that mean? Well, every company that operates in more than one national jurisdiction has to worry about possible antitrust liability in every single jurisdiction where it does business. So this liability can take three forms. This can be criminal liability at the hands of government authorities in each jurisdiction where the company does business. This can be civil regulatory liability, again, at the hands of government authorities in every jurisdiction where it does business. And this can also mean civil liability at the hands of private plaintiffs in every jurisdiction where it does business. And the expansion of this liability, antitrust and also other, due to these different extraterritorial provisions in different nations' laws, has both positive and negative consequences for companies operating in this environment. So I'm going to go through two case studies, one that I think highlights the negatives and another that I think highlights the positives or the potential positives. So first off, I'll start with the negatives. So number one, multi-jurisdictional liability means that increased company resources have to go to three things. Number one, compliance monitoring based on the laws of every single country in which the company does business. Number two, money spent defending the company from investigations and litigations in each country where it does business. And finally, payouts of fines or settlements in multiple jurisdictions, as well as possibly the PR hit of company executives facing jail time in different jurisdictions. So put simply, negative number one, increased company resources having to go to figure out how to handle all these different laws in all these different jurisdictions. The second negative, and this one's a bit more speculative, is to the degree that different national competition laws differ in either what conduct they prohibit or what conduct they are applied to in practice, what happens is the scope of these varied national competition laws taken together can broaden the range of what conduct is prohibited beyond the bounds of what any one nation actually wants to prohibit in its national law. Second negative. The positive, and I think there's only one true positive of this development, is that the opportunity for recourse on the part of victims, be they other companies or be they individuals, increases. Briefly, I'd just like to talk about how U.S. antitrust law can apply extraterritorially, and then I'll move on to the two examples. So when I'm talking about U.S. antitrust law, I'm talking mainly about the Sherman Act as applied to extraterritorial conduct. So the Sherman Act, as you probably know, prohibits a range of activity considered in restraint of trade. And it applies to conduct that occurs entirely outside the United States if that conduct substantially and intentionally affects U.S. import commerce. Secondly, the Foreign Trade Antitrust Improvements Act, which the goal was initially to actually take out some of that extraterritorial application of the Sherman Act, states that the Sherman Act does not apply to non-import commerce outside the United States unless that conduct has a direct, substantial, and reasonably foreseeable effect on domestic U.S. commerce, non-direct import commerce into the U.S., or export trade. So the example that I believe really highlights multi-jurisdictional liability as a minefield for companies that operate in multiple jurisdictions is the auto parts price fixing investigation. So very quickly, this is an investigation that's been going on for a number of years that relates to anti-competitive agreements for a range of at least 30 different types of auto parts. including automobile bearings, wire harnesses, basically anything you can think of that goes into making a car. The main companies being investigated, most are Japanese, some are also European and from other jurisdictions. And the anti-competitive conduct alleged, in general, takes two forms. Concerted efforts to hike prices and concerted efforts to rig bids. So a price hike example, taking the auto bearings example, is on a range of occasions in the 2000s, you saw steel prices going up. Steel prices are a component of bearings. Steel price goes up, companies agree, okay, we need to pass on this increase in this component to our consumers, but let's actually use this to add an additional increase in price beyond what the steel price increases would actually necessitate. And the second example of anti-competitive conduct that these companies allegedly engaged in is rigging bids. So typical, there's a request for a quote, company executives meet up and say, okay, company A, for this particular quote, you can provide the most favorable proposal, and next time around, company B will have that turn, next time company C, and so forth. And so since these companies sold these products, again, up to 30 different component parts that go into cars, to automobile manufacturers, to automobile shops as replacement parts, and eventually to car consumers as the components passed through manufacturers into cars and then on to consumers. Essentially what happened is that the price of one price-fixed product, again taking bearings, had the potential for leading to higher prices for replacement parts as well as the cars themselves wherever they were purchased. Fine. So where does multi-jurisdictional liability come into this? Well, a range of jurisdictions decided to investigate this conduct, again, most of which occurred in Japan, but arguably affected prices anywhere these parts and cars were sold. So this led to liability in the United States, in China, in Japan, in Singapore, in South Korea, in Europe, in Australia, in Canada, and just last year, actually in India as well in the aftermarket, as both my co-panelists have discussed. So in the US in particular, you saw almost $1 billion in fines being handed down based on the sales of 30 different car parts, as well as prison time, as well as fines for company executives, with as many as 17 out of 21 executives that were charged serving jail time. And additionally, you see ongoing civil litigation on the part of car purchasers who say that they paid too much for these parts. Aftermarket purchasers said they paid too much for these parts, and direct purchasers of the cars that they say cost too much because of the increased price in these parts. In Singapore, you saw an almost 8 million combined fine, $8 million US, to bearings manufacturers. And remember, bearings, to put that into perspective, is one out of only 30 products that allegedly were price fixed. And this fine at the time was a record for the Competition Commission of Singapore. And then finally, in India last year, you saw fines in the spare parts market of over 400 million. So, and that's just 3 jurisdictions, again, liability in more than 10. So what's the relevance here for Indian companies of this huge risk? I think the relevance is fairly clear. So basically, any product that is a constituent part of another, and this is most products that companies produce, can lead to liability in any jurisdiction where the final product, as well as the constituent part, is sold, creating a much more complex arena for companies to operate in. That, I think, is the downside. Now I'd like to talk about an example that I think highlights the upside. And that shows the extraterritorial reach of antitrust law from the US actually helping create freer and fairer markets. And the example that I think shows this is the potassium fertilizer component antitrust litigation. So basic facts of this, it's product, potassium-rich fertilizer component known as potash, mined mainly in Russia and countries around Russia, as well as in Canada and somewhat in the US, but less so. It's not really available elsewhere, right? This is something that's mined, it's a natural resource, and it's controlled by a few companies worldwide. The potash that goes into fertilizer is essential for farming and can't really be substituted, so it's a market that's pretty ripe for anti-competitive conduct. And the biggest importers are India, China, the US, and Brazil. So India imports 100% of its needs for this fertilizer component, and the US imports 85%. So I'm just going to summarize the cartel allegations that came out of the civil lawsuits in the US and then take them back to the relevance for India. So the civil lawsuit in the US, which eventually went up to the Seventh Circuit, their defendants, potash producers, would first negotiate prices for China. That would be their first location where they would negotiate prices. Then to Brazil and India, and then to the United States. So basically, the prices negotiated in China, India, Brazil would end up affecting the prices in India and in the US. And due to cartelization from 2003 to 2008, it's only 5 years, the price increased by 600%. And in part, this was simply anti-competitive agreements, and in part, this was also manufactured supply restrictions. So you would have some of the companies involved in these cartels shutting down mines at times they did not actually need to. So the price hikes showed up almost immediately in the prices of US imports in this product, and again, the US imports 85% of its needs, so they're kind of beholden to what these companies determine. So you see these price hikes show up almost immediately in the price of US imports, and a lot of US companies are purchasing the product directly from companies that are involved in the cartel. So this, in US jurisdiction, pretty clearly shows a substantial and intentional effect on US imports and gets you into the Sherman Act. Now, the Foreign Trade Antitrust Improvements Act, which I also mentioned, which serves to limit the extraterritorial reach of US law, comes in to analyze the allegations that the market that was determined in China, India, and Brazil is what affected US prices, right? So to bring this into the FTAIA exception that allows one to apply the Sherman Act, the effect has to be direct, substantial, and reasonably foreseeable. Now, substantial is fairly easy to show. We see a 600% price increase in 5 years. Foreseeable, we're talking about a group of companies that collectively control about 3/4 of the market for this product, so fairly foreseeable that something that they do is going to have an effect. And direct gets a little bit hairier from these three markets, China, Brazil, and India, to the US. No real stops along the way, but that gets a little bit more complicated. What are the results of this cartel? So in India, as a result of the price fixing, the Indian government actually had to pay increased subsidies to potash purchasers because of the necessity of this product in agriculture, right? It's hard to substitute, it's hard to use something else instead. And then as a result of these subsidies, the increased price in the US is enabled because there's a portion of the international market for this product holding up this price, right? In the United States, the litigation resulted in a $100 million settlement in 2013 after going up to the Seventh Circuit Court of Appeals, which in an en banc decision upheld US jurisdiction of both the allegations that relate to import commerce and the allegations related to the effects on US prices from this China, India, Brazil combined market. So what's the potential positive here? Well, most recently, the 2015 potash negotiations with China, which tends to be the first market that gets negotiated with, were disappointing to the potash producers. Lower prices than they had imagined. So they were not able to get the price increases they wanted, signaling that contracts with the other three major importing jurisdictions, Brazil, India, US, would also cite some improvement. So Does this mean that US litigation led to fairer prices in all 4 top import locales, in China, in India, in Brazil, and in the US? It's unclear to say how much, but quite possibly, and I think that's something for research. So here you have a case where the extraterritorial reach of antitrust laws, while some consider very over-intrusive, can actually regulate conduct and can keep markets functioning freely and fairly. So lots of negatives, but also occasional positives to this increased extraterritorial application of antitrust law. Thank you.